Well, thank you so much, Rob. Thank you for the enormous honor of being able to visit with you all today and to talk about a subject of mutual interest. I have to begin with a disclaimer. I am not going to talk about HB2.
Not until the questions section.
Except for one thing. It's too compelling to ignore. So I am here in Raleigh, of course, here at the NC Policy Watch, and actually here to talk to a group I suspect needs no introduction to controversies, particularly constitutional controversies in the state of North Carolina. I will have to tell you that Amendment 1, HB2, and the Senate obstruction of President Obama's nomination to the Supreme Court all have one thing in common. They will all fail. And they'll all fail for similar reasons. To begin with, they're on the wrong side of history. Beyond that, the American people don't support them. And even beyond that, they're all grounded in very base, coarse impulses rather than the things that define the best in us. The support that you'll hear and know about when it comes to the Senate's obstruction of Merrick Garland's nomination to the Supreme Court is largely driven by partisanship and lacks support in history, the Constitution's text and logic, and that's not a good start. I hope it will be of some interest to you to talk a little bit about the sort of basic process for Supreme Court nominations and some of the basic issues relating to that process. And then, of course, we can talk further about it if you have questions or comments. But to begin with, we all know the tiny little bit the United States Constitution has to say about this. The Constitution says that the President has the power, has the authority to appoint, with the advice and consent of the Senate, justices to the United States Supreme Court. And so President Obama obviously has done his part. He's nominated somebody to fill the vacancy left by Justice Scalia. And I should say, just somewhat parenthetically, but because I'm a law professor, the parenthetically is a little long. I come to this with slightly mixed feelings. Justice Scalia was actually my constitutional law professor. And I have known him, or had known him, for over 3 decades. And actually, I had helped schedule one of his last public appearances, which happened at the Union League in Philadelphia, at which we had the opportunity to talk briefly. And he was always, to his credit, very cordial to me, very tolerant, knowing that I didn't always agree with him. In fact, the very last thing he said to me was, Professor Gerhardt, so, how am I doing? He would always say that with a twinkle in his eye and a smile on his face. And I said, Justice Scalia, we just don't have enough time to talk about that. And he, of course, laughed, and and so I don't talk about any of this with any great deal of sort of personal relish. The circumstances that often give rise to vacancies are, in a very real sense, tragic ones, unfortunate ones, but inevitable ones, oftentimes. And it so happens that when we talk about Justice Scalia's vacancy, it's important, I think, to define at the outset, even before we talk about the actual process, the context in which it arose. So Justice Scalia died, as Rob reminded us, February 13th. And what is, I think, particularly significant about that is sort of more than one thing. Nobody saw this coming. And I think you cannot forget that fact. I happened to be at a conference in Atlanta on the Thursday and Friday preceding, and one of the last panels at that conference involved 3 of the nation's leading journalists covering the United States Supreme Court. including Dahlia Lithwick from Slate, Bob Barnes from the Washington Post, and Adam Liptak from the New York Times. And as Adam would tell you, and I was there to see this and know it's true, on this last panel, somebody said, well, will the Supreme Court be an issue in this upcoming election? And Adam, fast out of the box, said, there's no way it's going to be an issue. Nobody is sick or dying. We don't expect a vacancy. You know, when people have said for decades and a lot of years it's going to be an issue in the campaigns, it turned out never quite to be. He said this on Friday. Then on Saturday, he was headed from Atlanta to St. Louis, where he was conducting a really special class at Washington University in St. Louis on the Supreme Court. And so he was in class all day on Saturday and had turned his phone off. And so if you want to know why the New York Times story on Justice Scalia doesn't show up until 4 a.m. on Sunday morning, it's because Adam didn't turn his phone on until about 6 p.m. And then he turned his phone on and, you know, excuse my French, all hell breaks loose. And he realized, you know, he's got messages, his phone's about to burst and everything else. And the entire world of constitutional law changed. And what you are largely witnessing, sort of to tell you how, to tell you one of the takeaways on this, is what happens when your national leaders decide to improvise. And much of what you've been watching over the last several months is a number of senators and others improvising in response to this vacancy. They didn't see it coming. They didn't have exactly a game plan or strategy in place to deal with this, and the same is true for the other side. And so a lot of what we're seeing is literally being made up on the spot. If it seems kind of not well thought through, and it seems like people hadn't really sort of considered this very deeply or thoroughly, it's because they hadn't. And so really from the very beginning, we've seen sort of the parties, in a sense, divide on this pretty quickly. And one of the critical reasons for that is because of the part of the Constitution I just told you. The president nominates Supreme Court justices, but with the advice and consent of the Senate. And the Senate, with 55 seats controlled by Republicans, is more than aware that this is going to be a transformative appointment to the United States Supreme Court. That's no secret. Everybody understands that whoever replaces Justice Scalia is going to make a tremendous difference in the future of constitutional law. And just to put it in some perspective, I mentioned Justice Scalia being one of my constitutional law professors, and up until the day he died, it literally shaped the world of constitutional law that I taught and lived in, that we all sort of taught, and I suppose, and lived in. And that court, of which he was a member, had been shaped by Republican presidents and had not been dominated by or had a majority of Democratic appointees for over 4 decades. We have not lived in a time when there was a majority of Democratic appointees to the Supreme Court until when I was in law school and before. That dates me to some extent. Yeah. But it's worth thinking about what that means. That, again, really underscores the fact that this is not just your sort of everyday appointment to the Supreme Court, as if there were any such thing now or forever in the future. This is really sort of the beginning of a holy war. This is the beginning of thermonuclear war. This is an appointment that each side understands. Almost everything they stand for and care about is at stake. So if they fight over it, it shouldn't be the least bit surprising. A process that puts the president and senators in control is necessarily a political process. So we shouldn't be surprised that partisanship and politics are part of it as well. That's the context. At the same time, we need to think about a second thing, which is, okay, what else can we, do we know about this? And is there anything, of course, history could tell us? This is where some of the dialogue takes place. There's a lot of talk about what history has to teach us, if anything, about this, and I can only mention a couple things here. First is, I think, while there's some predisposition to invest history with some kind of sacred quality, we shouldn't. History doesn't bind us. History doesn't tell us what we should do. History might be able to tell us a little bit of what we could have done or could do, but it doesn't tell us what we should do. And as we look to the past, we should keep that in mind. And you can see some of the improvisation on the part of Republican leaders in that the rationale for their opposition has changed. Initially, it was grounded in the idea that we don't do this in presidential election years. The biggest problem with that is that's completely counter-historical. There's no history at all to support that. And I don't say that it's just a partisan. I've worked in this process for many decades. Did have an opportunity to sort of write a book on the subject, and more than just that, have a chance to consult with senators on all this. And there's no support for the idea that during presidential election years, the Senate shuts down for business. That just doesn't happen. And it is true that in the modern era, the Senate has slowed down when it comes to lower court nominations. But for those of us who care about distinctions, slowing down for lower court nominations is not the same thing as slowing down for Supreme Court nominations. And in fact, over 20 presidents have made successful Supreme Court appointments to the Supreme Court during presidential election years, or even as lame ducks. Now that's almost half. I'm not good at math, but it's almost half, which is a fact. So as we go through this, if there's nothing else we can do, we can try and keep everybody honest by making sure that they get their history correct. When we do look at history, we can see a couple things beyond what I've already said. Over the last 100 years, to the extent it is relevant, the Senate has actually taken action on every single Supreme Court nomination with the exception of two. And the only two times it didn't were the two nominations that were withdrawn. President Reagan's nomination of Douglas Ginsburg, withdrawn within 9 days of that nomination, and President George W. Bush's withdrawal of Harriet Meyer's nomination, which also was trying to break that record of 9 days. And otherwise, every other Supreme Court nomination has actually had Senate consideration. A second thing, we even have Senate consideration of Supreme Court nominations during the Civil War, during World War I, during World War II, during the Great Depression. So the fact that there are important political and other events has not stopped the Senate from at least holding hearings and giving consideration to the particular merits of a particular nomination. That's the history. Now, when we move beyond that, we can ask the question, okay, does the Senate have the power to do nothing? This is a very interesting question in the abstract. As a practical matter, it doesn't take much for the Senate to actually comply with its oath. And so there are times when the Senate does act, does give consideration, and in fact may reject a nomination, or does act, does give consideration, and in fact after floor debate or whatever else, may not take a vote. That's happened a couple times. More often it's actually acted positively. As Jeffrey Stone, the University of Chicago Law School has pointed out, when you consider the record on how the nomination of a well-qualified moderate nominee has fared in modern times, they are confirmed 100% of the time. That's the record. And so it's fair to say that to some extent the Republican leadership is swimming upstream on this one when it comes to at least historical trends or historical patterns. Other question about history that comes up, inevitably is what's the closest analogy? Now, this is always, it's a tough thing to answer. It's the kind of thing a law professor would ask is what's the closest analogy? And the secret that I can tell you as a law professor, maybe April would agree, is there's no right answer here. But some answers are more correct than others. Now, you can spend a lot of time thinking about it. And so my estimation is that the closest analogy, the only thing that really sort of seems to come, I think anything remotely close, arose when Andrew Johnson was president. Now, many of us probably don't remember that because we weren't here. If you were here, then you should be the one speaking. And so what happened when Andrew Johnson was president? Well, of course, Andrew Johnson was Abraham Lincoln's second vice president, a man that Lincoln said after his inauguration, keep that man away from me. And so Johnson becomes president because of the unfortunate and tragic assassination of President Lincoln. When Johnson becomes president, essentially nobody wants him to be president. And then he proceeded to alienate everybody. And so the Republican leadership in the Senate and Congress at that time responded by passing a law. And in fact, the seats in the Supreme Court are created by Congress through legislation. So Congress passed a law which prospectively abolished the next two seats on the Supreme Court if their occupants died during that time period. So they didn't want Johnson to make the appointment. And in fact, there were two people that did, in fact, die, and their seats were then abolished. Johnson then is impeached and barely escapes conviction. He leaves the White House. Ulysses Grant comes in, and Congress recreates the two seats, and Grant fills them. That's the closest thing to analogy. Now, if you want to make an analogy between Andrew Johnson and Barack Obama, I would say good luck. If you want to think about the two people that had the highest number of votes publicly for President of the United States, the top two are Barack Obama and Barack Obama. Johnson got 0. And then you can just sort of go on from there. And so we can look at some of the rationale, and I want to sort of pick that apart and get to what I think is I guess what I call it the most credible rationale. So one rationale we've already heard, which is, okay, we should let the next president of the United States make the nomination. That's why we're doing this. I think, of course, I have a lot of problems with that, but one problem I have with that is I actually don't think the people who say it believe it. Because I think a lot of people who say that they don't want the next president to make the nomination would actually be perfectly happy voting against the nominee even once the next president got elected. For example, Pat Toomey from Pennsylvania has said more than once, we should let the American people make that choice. Choose the president who's going to make the next appointment. Well, when Pat Toomey came into the Senate, he then proceeded, less than 2 years after Barack Obama's first election to the presidency, to oppose Eleni Kagan's nomination to the Supreme Court. It had nothing to do with the American people's preferences. So much for letting the president, in a sense, make that choice. And I don't think Senator Toomey believes that. In fact, he's going on to say, no, there's a second rationale. The second rationale, and this cuts closer to home, is that the Senate needs to take extra special care because this is Justice Scalia's seat, and the court split 4-4, roughly down the middle. Again, my math is always a little shaky, and so because it's that seat, we need to, in a sense, turn to the American people again to kind of have them validate or validate principle, whatever principle it may be. For example, if the American people were to elect, I'm going to just take a hypothetical, Ted Cruz, then presumably that nomination might look a little bit like what Justice Scalia did, and maybe Senator Toomey would say, okay, that person looks like, I see some public support for that, and therefore I can go with it. There are a lot of this is just a variation really of the first argument. I'm not terribly moved by this argument either, again, because what the linchpin of it is really the ideology or philosophy of the nominee. It's not about what the American people say or don't say. Because the American people could speak to this. They could elect, let's say Hillary Clinton, President of the United States. But my guess is if Senator Toomey's still in the Senate, he's not going to pay attention to that. He'll pay attention to the fact that he just got reelected to the Senate and say, it's really the people, Pennsylvania people. That's who I'm going to listen to. So you'll notice the ball keeps moving. It's not fixed, which, by the way, if this were a matter of constitutional law, should make us pause. And that's because this isn't grounded in constitutional law. It's grounded in partisanship and politics. Now, when we strip everything away, I think we can see a couple things. I want to first point to what I think is part of what is going on, and then I'll point to what I think is the more credible explanation for what's going on. And I say this without as much trepidation as I used to say it. I should tell you, as preface, that I grew up in Alabama, and I grew up in the 1960s in Alabama, and I grew up as a Jew in the 1960s Alabama. There were 4 of us. None of whom are living in Alabama now. And all I can say is, I think I know racism when I see it. And I think some of the opposition is driven by the basest, coarsest feelings that may exist. It has to do with the very simple fact that a black man occupies the White House. When Mitch McConnell says, no, this president won't make it, that's not a stand on principle. That's a stand on racism. And I've seen stands on racism. George Wallace was the governor when I grew up. And I ran as far away as I could, all the way to North Carolina. No. And now look at it, yeah. So, I don't think we can ignore that. And one reason I point that out, I hate to tell you, is because with the flip of a page, racism is not going to go away. And I also hate to tell you, with the flip of a page, it doesn't mean that a woman who gets elected president is going to be any better off. I don't know that I need to tell you that. But I think sometimes it needs to be expressed openly, because I do think there is such antipathy and hostility to the progress of women in society. It seems to know no bounds. But I believe, to some extent, it is generational. And I believe this generation that is coming up in a very different way. Not to say it's perfect by any means, but I think that there are hurdles to be gotten over, hurdles yet to be dealt with, that we can expect will arise. And so the road, and nobody knows this better than Hillary Clinton, the road ahead is not going to be easy. So where is the principle in all this? Well, the principle, in a sense, is intertwined with some of this. And it is, of course, the basic principle that, yes, we who oppose President Obama making any nomination believe that the next Supreme Court justice should look and have exactly the same outlook that Justice Scalia had. The principle is a principle that of commitment to, lack of a better way of putting it, to sort of strict adherence to original meaning, strict adherence to sort of textualism, strict adherence to so those things that presumably the court had been adhered to while Justice Scalia was the pivotal vote. So I have a couple thoughts about that. I'll concede for a moment that that's a principle. But I also think that that principle tends to conflate results with ideology. It tends to sort of only treat as correct those outcomes we like. Now, I can give you an example from Justice Scalia. Now, Justice Scalia knew that that he and I would not always see eye to eye, and I don't think there was anybody more than just Scalia who really hated the idea of the Supreme Court confirmation process becoming politicized. But Justice Scalia, who adhered so strongly to original meaning, only twice in his almost 30 years on the Supreme Court voted to strike down laws for violating equal protection. Only twice. The first had to do with laws that were what we describe as affirmative action measures. Now, you may say that maybe that could be squared with original meaning in some sense. Maybe, as he would say, because there was a general sort of hostility and opposition to what we call race-based laws, race-based classifications. Maybe. But it's the second case that kind of proves the point. The second time he voted to strike down a law for violating equal protection was Bush versus Gore. And George W. Bush, I'm pretty sure, doesn't fit into that first category. The law that was struck down in Florida had nothing to do with race. It was what we typically would call a neutral classification, which typically would get the lowest levels of scrutiny or the greatest degree of deference. And so even the most strict adherent to original meaning wasn't necessarily as adherent as one might imagine or want. But to come back to it, the biggest problem with, I think, the principle that may be driving or animating all this is I'm not entirely sure how many people who actually are opposing this really are committed to that principle. To put it another way, they aren't saying so. You don't find Republican leaders until somewhat more recently and somewhat haphazardly saying, oh, there's also a principle involved here. Well, it wasn't the initial stance. The initial stance of Mitch McConnell was, within days of Justice Scalia's death, Mitch McConnell said, oh, this president is going to fill it. It's going to be left to the American people. Nothing about transformative appointments, nothing about this court being split, nothing about principle at all. And then when some members of the Republican caucus said, well, what if in the fall we get shellacked and we need to think about whether or not the Garland nomination somehow is going to be more acceptable to us than, let's say, a different kind of nomination. What about that? And McConnell said, no, I said this president isn't going to make it. Again, nothing about principle in any of that. And so if you want to make it about principle, my suggestion would be make it about principle. Make it openly and expressly about a principle of jurisprudence. But the fact is that the Supreme Court confirmation process is a very tough place. It's a very tough place to make very neat and careful distinctions among people's outlooks based on how you think they would vote. The people that have run into trouble in the process have not really run into trouble because they had, I think because of ultimately problematic ideologies. I think it's because they ran into trouble for a couple reasons. Ethics was one reason. I think competency was another. And then another, I think, is that they simply were, to some extent, way outside the mainstream in terms of what was acceptable or public approved sort of jurisprudence. John Parker, as you may know, nominee from North Carolina, rejected. He was on the Fourth Circuit, rejected for the Supreme Court. Parker's rejected because he had views on not just segregation but labor that were thought to be, at least by the Senate at that time, unacceptable. And Judge Bork, who was an eminently qualified nominee, is the other kind of poster child that's oftentimes brought up. But I'm actually of a view that Judge Bork's biggest problem was Judge Bork. And I've said this both when I've worked in the Senate and other places, because when I worked in the Senate, lots of people would come up to me and say, well, why can't we make these hearings like the Bork hearings and everything else? And after I finished laughing, I would say, well, there are a couple reasons. The first is that the objective on the Senate side, if you're in the majority and you want somebody confirmed, is not to make it into a popular TV show.
Right.
You want it to be the least watched, most boring production you could possibly imagine. Now, you may not quote me on this, but I will say during the course of one of the hearings on which I worked, somebody, one of the staffs came to me, and it was in the heat of the moment. He said, "Oh, good, Michael Jackson just died." Why would they say that? Because it took the cameras away. And that made it even less volatile, made it less prone to any kind of public interest. The more, lawyers will tell you, if you have, and you're lucky if you've never heard this before, lawyers will tell you if you have to testify or anything else, what you should be doing is you should give the shortest, succinct statement you can in response to a question. I should say, the shortest, honest, succinct statement in response to a question. That is not what Bork did. And what we would say to any nominee today, Republican or Democrat, doesn't matter what party, is shut up. And so I often think of a friend of mine from law school, and I tell this to my legislative process classes. It's one of my favorite moments in legislative process because it really illustrates this point. My best friend from law school clerked for somebody named Ruth Bader Ginsburg. And when she was nominated to the Supreme Court, she had asked my friend essentially to be her counsel. And if you go back, and you can see this on TV, and there's a point in which then Chairman Biden asked her a question. As you can imagine, Chairman Biden's question goes on for quite a while. And he goes on and on for some time. And then he stops, and he says to her, "Do you have a response? Anything you want to say?" And then she looks at him, and then she leans back, talks to they whisper back and forth. Then she leans forward and goes, "No, Senator." That is why she's sitting on the Supreme Court of the United States. You know when to talk, and you know when not to talk. That is not the moment to start going off on a tangent or anything else. That is exactly the moment to say, "No, Senator, I got nothing to say." And that's exactly what I think, that is one of the lessons from the Bork hearings. The lesson isn't, oh, let's make them as dramatic as possible. The lesson is, let's make them as boring and non-substantive as possible. If that's the case, then it's really hard to imagine you can turn a Supreme Court confirmation hearing into some kind of seminar on how to interpret the Constitution. It's not going to work. And plus, people's votes are probably largely going to track their political partisanship anyway. So when all is said and done, it's a very hard thing to point to say, oh, that's going to vindicate this outlook or that outlook. The fact is we've had somewhat conservative people confirmed over the years, somewhat liberal people confirmed over the years. And if you want to talk about the two most vicious hearings in the history of the United States Supreme Court, I think in some ways Bork finishes third. The two most vicious Supreme Court hearings in American history involve first Louis Brandeis, hearings that lasted over 6 months and were infused with anti-Semitism, and the hearings for Thurgood Marshall. And I would say those two probably are the two most distinguished lawyers and judicial nominees in the 20th century. And those hearings could not have been uglier. And at one point, President Wilson goes to Louis Brandeis and says, look, you're getting beat up in the Senate. I think do you want to come forward? He goes, no. Exactly the same as Justice Ginsburg's response. Which is, Brandeis understood that there's nothing to be gained really, or you've got to be really careful about this, but not much to be gained by going into the lion's den like that and then just allowing yourself to become a punching bag. So I'm not convinced the hearings are going to become an elevated seminar in constitutional law anytime soon, unless, as I often say, the nominee really likes his current job. If that happens, if you really, really love being on the DC circuit, go ahead, do it. But you don't go in there and open up and talk more than the senators unless you are prepared to be rejected. Because the more you say, the more you get in trouble.
North Carolina Channel is made possible by the financial contributions of viewers like you who support the UNC TV network.